Hi, welcome to Module 11, Week 13. This is on loopholes. You'll notice in the curriculum that there is one law review article this week. It is not particularly interested in loophole issues, although you can kind of look at that in the context of that article, and we'll talk to about that when we get there. But in the curriculum for this class, you'll most clearly find discussions about loopholes in part Roman numeral 2 of the book, Why is the Law So Perverse? And we've covered that earlier this semester, so the chapter this week is not included in that, as I've tried to time the book so that you get it completed in order to do your final project by the end of the semester. But you might want to look back on the part of the book that has to do with loopholes. So loopholes, as we've discussed previously, are commonly associated with lawyers. They're glitches in the formation of law, statutory or case law, that allow clever lawyers to help their clients do things that appear to subvert the purposes of that law. And this module is going to talk about that phenomenon. Like I said, in part 2 of the book previously, we've talked about things like forum shopping, asset protection, litigation proofing, and other things. And you're going to see a further definition of legal loopholes in the lecture notes for this week. It defines legal loopholes as a provision or an ambiguity in the law, regulation, or contract that allows an individual or organization to exploit a technicality or gap to achieve the result that may be unintended by the drafters, often without technically breaking the law. Loopholes often arise due to vagueness, imprecision, outdated language, or conflicts between statutes or regulations. And they're typically closed when they are detected and seen as undermining the law's intent. So I would have explained in an earlier section, for instance, that I helped draft a statute under Ohio adoption law that allows legal custodians to adopt without parental consent when there is abandonment, which is defined as de minimis support or contact within a 1-year period preceding the filing of the adoption. But what I failed to realize, and the member of the House of Representatives in Ohio, the legislative committees there, we all didn't catch the fact that it allowed the legal custodian, but didn't account for the spouse of the legal custodian. So in fact, if one person in a marriage had legal custody, the other person was not allowed to. And that was later corrected, but it took about 9 years for the Ohio modernization of adoption law to go into effect this past March in 2025, which corrected that and added spouses in place. So it was only once there was adoption cases, including mine, not my adoption, but one of my clients' adoption cases, where it came to light that we had neglected to include spouses and then had to later amend the law to include that. So it created a different issue that caused more litigation that was not otherwise intended. So looking at the notes here for the lecture that are included in the module gives you some examples of legal loopholes, such as tax avoidance and campaign finance. What happens is super PACs will contribute to an individual that's running for office, a candidate, and that allows them to bypass direct donation limits on individual campaigns. They talk a little bit in your lecture notes about Airbnb and short-term rentals being a way that sometimes goes around zoning laws or lease agreements. Bankruptcy and asset protections, ways to avoid losing assets in bankruptcy that weren't intended at the time it was written. Corporate veil piercing avoidance. Business owners may structure their businesses as separate legal entities to protect themselves personally from liability. And even as an attorney, that's something that you might want to be talking to somebody about, that if you're a solo practitioner, do you want to have assets, for instance, in your spouse's name or in a different place in case there is litigation against you? So that's something that you might want to be looking at as you're going into law practice. Is there things that you need to structure in your corporation, your solo practice, your law practice, in order to protect yourself financially? Talks about a few other things in there as well. And then as you move to page 2 of the lecture notes, gives you some hypothetical questions to look at, looks further then and gives you more insight into some of those examples that are provided on page 1, such as the tax loophole scenario, the zoning loophole hypothetical, particularly in today's day and age with Airbnbs and online short-term rentals that might not have been considered at the time that the zoning went into effect or the lease went into effect, therefore creating this hole or this gap in what was intended versus what is now occurring. Also talks about patent evergreening, where a drug manufacturer can make slight modifications in its patent and therefore have its patent for its existing drug extended multiple times over the course of that drug so that it can maintain, that company or individual can maintain exclusivity for a longer period of time. Also talks about the bankruptcy asset loophole in greater detail in your lecture notes. So be sure to look at those, and like I said, for context, look back at part 2 of the book. Then there's a legal law review article that we're looking at this time in this section. It is from the California Law Review. It's written by Bundy and Elhag, and the article is "Do Lawyers Improve the Adversary System? A General Theory of Litigation, Advice, and Regulation." And so the article gives great amount of time and consideration to various fact patterns and what the implication of legal representation is, what the implication is of confidentiality, what are the implications of sanctions in what discovery is provided, what discovery is not, what's suppressible, what is not suppressible. So it talks on page 315, the first page of the article, that the lawyer's role in the adversary system frequently is calls for conduct that appears to thwart the truthfulness or just outcomes. So that there's a view of lawyers that when they are zealously advocating for their client and maintaining confidentiality, that this causes attorneys, and I'm looking now at the second page of the article, 316, that there's a perception that this causes attorneys to engage in a host of dubious activities. These are defined as withholding evidence even when the resulting record of the court is radically incomplete, presenting documents or testimony that the attorney believes based on information unavailable to the tribunal to be false, discrediting through cross-examination witnesses the lawyer knows to be truthful, and arguing for inferences from the evidence that the lawyer knows are unwarranted. So that then raises questions about the social desirability and moral standing of the role lawyers play. Defenders argue on behalf of lawyers that lawyer-aided adversary fact-finding is more likely than the alternatives to produce an accurate decision because it leads to a better evidentiary record. So that's what they're asking those questions throughout this article. On 317, it talks about each lawyer will vigorously attack unreliable information that the opposing counsel presents. Such information will either be withheld or promptly discredited so that the tribunal gets more accurate information, is the argument. And so it asks the question in the article, why should we believe competition has an inherent tendency to enlighten the tribunal? And it's going to ask that question throughout, and states that lawyers enable parties to, among other things, investigate, organize, and present information in digestible formats and expose inaccuracies in the opponent's information. So as you're moving through the article, it talks about their aim is to provide a comprehensive and accurate examination within a rational actor framework of the considerations that determine the informational effect and social value of litigation advice. I'm reading that from page 318. Also talks on that page about the competitive presentation does not invariably prevent or correct inaccuracies, especially when one party has more access to legal advice or can control or suppress information. So it's going to talk throughout about what happens when one party has an attorney and the other one doesn't, and what the implication is of that scenario upon the presentation of testimony and evidence. I'm going to skip over to page 323. Talks about that there are 4 basic activities that influence the information reaching the tribunal. First, each party seeks to identify information through investigation. Second, each party seeks to prevent the opponent from identifying information by withholding it or suppressing it. Third, from the information that a party has identified, each party selects the information to present to the tribunal. And fourth, the parties seek to lower their own evidentiary sanctions and raise those applicable to their opponent. So I've long told people, I was on the bench for about 10 years as a magistrate, the court cannot hear all the testimony and evidence that exists. If you have a 20-year marriage and a 4-hour hearing, the court is going to hear the testimony and evidence that the parties choose to present. Things are left out by omission and things are left out by commission. Sometimes people will actively lie in a courtroom, which is perjury. So the information the court gets, though, is this very narrow, focused information that the parties and the attorneys present to the court, because that whole 20-year period cannot be presented in that short period of time through testimony and evidence. The article talks then on the next page about different types of things. The first thing it identifies is a discoverable set, which is the information that is presented, and it is because it is perceived that the evidentiary sanctions exceed the harm of producing. So these are the things that when there are discovery requests, interrogatories, requests for production of documents, subpoenas, or depositions, there's a discoverable set of information that each party is going to decide there's greater value in producing that information than in withholding it or suppressing it and possibly having sanctions. Also, each party has information in their possession, and that the disclosure of that cannot be compelled in some case. So that's the controlled set is what the article is talking about. Page 325 also talks about information that is potentially available to both parties. They both signed a contract. They're both involved in the contract. They both have that information. That's the commonly available set in this article. And then the fourth set it talks about is the suppression of information on, again, page 325. So we're looking at the attempt by one party or the other to prevent their opponent from getting information, so suppressible information. So suppressible is if one of the parties would be willing and able to suppress it under some circumstances to prohibit the other party from getting that information. So page 327, one of the advantages of having legal counsel is that investigations during a lawsuit, or sometimes even occurring before a lawsuit happens, investigations have a positive value to the extent that they are expected to yield favorable information. That typically an attorney is not going to advise their client to engage in an investigation that is going to give information that is harmful to their party, so that you're seeking information that is going to be beneficial to your client when you're seeking that information. And then on page 330 also talks about secondary information that influences the level of evidentiary sanctions. So turning then to page 336, the article states that several informational effects of litigation advice are unambiguously positive. What are some benefits of having legal advice? And it lists the following. First, that legal advice helps parties sort the relevant information from the irrelevant, so that you're condensing what you present and how you present it to the court, the tribunal. Second, whenever the same information is available to both parties, legal advice to either party about how to categorize information as favorable or unfavorable will normally increase the amount of favorable information that the advised party presents more than it decreases the unfavorable information that she presents. So having legal advice means that you're leaving out the irrelevant, but you're also narrowing down what benefits your client the most. If there are 300 pages of text between two parties in a custody dispute, the attorney is going to understand that in a 2-hour hearing, you can't identify those and have somebody testify to them. So you're going to need to be narrowing the scope of that and picking the ones that are the best, that prove the facts that support your theory of the case. And third, legal advice increases investigation and thus the presentation of information that would not have been available without legal advice. So finally, for all legal advice provided, lawyers' personal susceptibility to evidentiary sanctions will sometimes decrease withholding and suppression of unfavorable information. Attorneys are repeat players. They have ethical rules and obligations. And so the attorney is also going to be looking at what evidence is provided or not provided within the framework of the legal system and the expectations of their professional and legal obligations. Suppressible information is talked further about on page 341 and talks about that reducing irrelevant information, reaching the tribunal is one of the goals of having attorneys, and increasing the total amount of favorable information reaching the tribunal. So this also reduces the amount of unfavorable information. So you're reducing irrelevant information, you're reducing unfavorable information. And that there's no net effect to this is what the author says in skewing advice, because it's creating this narrower set. So the conclusion the article comes to on page 341 is that unilateral litigation, one party has an attorney, advice about how to categorize information, has several positive effects, is the ultimate conclusion of their analysis. They also look at the effect of bilateral advice, what happens when both parties have an attorney, that's on page 342. And in this case, both parties receive advice. Each party presents less irrelevant information and more relevant information, and it increases the presentation of favorable and unfavorable information about both parties. So that's what happens in bilateral, that you're having more relevant information, but you're actually having more unfavorable about the opposing party, more favorable as to you, but the other party's doing the opposite. So there's a balancing there on what happens there. In page 343, it looks at the effects of unilateral advice on investigation, stating that lawyers better understand the full range of potential helpful information. A family lawyer who's practiced for 20 years is going to know what the court is looking for, or in my case, where I sat on the bench for approximately 10 years on family law cases before opening my practice, I'm very narrow focused on what I'm presenting to the court. If we need to talk about debts and assets, I'm going to have the deed for the property, then I'm going to have the appraisal for the property, and I'm going to have the mortgage, and I'm going to have a marital balance sheet that says all of those things, those exhibits, and then what the value is that we have left to divide between the parties. So it's going to be very much to the point on what is the information I need to give the tribunal and what are the exhibits that I need, and not a bunch of periphery irrelevant things narrowly focused to what the court needs to make that decision in that case. Advised parties will, with a lawyer, conduct investigations that sometimes you would not otherwise conduct, because the lawyer, again, with experience, will know what you're looking for, what information you need to best present your case in the most informed and best light to the tribunal. Investigations, when they're complete, an advised party will make better decisions about how to categorize their information obtained because of legal advice. So legal advice talks on the next page, on page 344, legal advice improves a party's accuracy in calculating their expected value of their feasible investigation, and advice that influences investigation should provide a party with a larger pool of information which they can present to the court. Advice influencing investigation should strongly increase the presentation of favorable information. The lawyer is looking for information that is going to be helping their client, their theory of the case. So you're going to be increasing favorable information, and the advice thus increases the amount and proportion of relevant, non-suppressible information reaching the tribunal. Out of the set of information that would have been identified with or without legal advice, the increase in favorable information exceeds the decrease in unfavorable information with legal advice. And even when there's unilateral advice, that increases the total favorable information reaching the tribunal more than it decreases the total unfavorable effect. In a bilateral advice, when both parties have advice, and I'm now on page 348. The net effect of bilateral legal advice is to increase the favorable and the unfavorable information about each party reaching the tribunal. So the tribunal, when both parties have attorneys, is more likely to get a fuller picture of the issues before the court. Legal advice, the effects of legal advice on the efficiency of evidentiary sanctions. This again is on page 348. Legal advice, first, the advice can correct misperceptions of expected evidentiary sanctions if the clients misunderstand that. Second, legal advice can influence the actual level of those sanctions. And finally, the legal advice retaining an attorney can increase the effective evidentiary sanctions the client faces. So also, as to the matter of sanctions, the attorney is going to have more knowledge as to that and what needs to be disclosed, what does not need to be disclosed. Turning then to the lawyer's personal susceptibility to evidentiary sanctions, whether that is or is not a motivating factor for lawyers, that's on page 352. It says sometimes legal advice will decrease the amount of information suppressed or withheld because of the evidentiary sanctions applicable to the lawyer giving advice. Lawyers are repeat players. They're going to be in front of that court multiple times. They're going to know what their ethical and professional duties are, and they are going to be aware of what the evidentiary sanctions are. Disciplinary rules in all American jurisdictions forbid lawyers from knowingly assisting or counseling the criminal or fraudulent with holding or suppression of unfavorable information, and require lawyers to withdraw when they know their clients are using advice for those purposes. If you know your client is going to perjure themselves, you need to withdraw from the case. So that is going to change what is presented to the court, because attorneys are not going to step into that situation and mislead that tribunal, because they need to maintain their license and their ability to continue to practice. So on page 357, their summary of this section says, on balance, legal advice increases the amount and proportion of relevant advice that is provided to the tribunal. It looks then on some other factors, some complications that happen in different cases, and that'll impact evidentiary matters, page 361. So complications into our basic accounting examination of complications that alter the first conclusions that we've talked about. They look at, number one, factors relating to the cost of litigation and the possibility of settlement. Two, parties and lawyers who are law-abiding or truth-telling. Number three, information that influences the tribunal in a socially undesirable ways. And number four, unequal distribution of information, access, or errors. This discussion, again, starts on page 361. And so it talks in the first section about the cost of legal advice, that lawyers charge fees. So parties' incentive to engage in litigation conduct may decrease if legal fees are such to make the conduct more expensive. That your clients are always going to be looking at what's the overall cost here, what's the cost benefit analysis. And so there are costs associated with legal representation, and therefore that's going to factor into decisions that are made by clients throughout the case. But legal advice, page 365, the conclusion of the article is that bilateral advice, again, both parties having legal representation, typically should increase the likelihood of settlement. This goes again to the attorneys know the value based on their advice, their expertise in an area. They're going to know the value of the case, and therefore they're able to better inform their clients, which then leads to a greater likelihood of settlement because there's realistic expectations in cases. Page 367 talks about uniform party motivations, and if the parties are uniformly truth-telling, that the effect of legal advice will be even more positive. So if you have truth-telling parties, they're more likely to listen to the attorneys. They're less likely to want to have sanctions and legal detriment from their activities. Talks then about truth-telling attorneys on page 363, that if the lawyers are truth-telling, that the susceptibility to sanctions, their concern relating to that is going to be greater. So they're going to be more likely to be in compliance with discovery rules and regulations and what is requested. The article then looks some at, on page 370, about information that reaching a favorable tribunal may have a favorable unfavorable impact that is misleading. So what happens when information influences tribunals in undesirable ways? So there's some discussion that starts on that page as to that. Conclusions in this section on page 379 states that the likelihood of adverse effects is greatest when advice is unilateral, when one party is pro se and the other is represented. That's what they're talking about in unilateral. And when the party receiving advice is a sanction optimizing violator or an unjust accuser, can control or suppress a large portion of the relevant information as opposed to a truth teller. So the personality and motivation of the party is also going to impact the adverse effect on providing information. Conclusions as to that section appear in page 395, where it talks about the informational effect of advice that, like bilateral advice in our basic account, increases information without increasing skew, are socially desirable. We're trying to give the tribunal all the information it needs. We're trying not to skew it. So that is beneficial. So there's a strong support for bilateral advice unless certain special conditions are present, but overall informational effects of legal advice is that it increases information, but it does, the authors determine, also increase skew, but still is generally desirable for that to occur. When advice, page 396, where advice decreases information and increases skew, it is then socially undesirable. The article turns to looking at attorney-client confidentiality and whether that is beneficial or not beneficial. Page 403, the article states that information sharing caused by confidentiality improves the attorney's ability to give advice. The more information you get from your client, the more you're able to give them better advice. That's an advantage of having attorney-client confidentiality. And the article states that on balance, advice resulting from the sharing of information caused by confidentiality should increase the information going to the tribunal because the attorney is operating from a position of more information and then better able to inform their client as to that. That conclusion that I just read to you is from page 404. The final conclusions of the article begin on page 419 and they're on 419 and 420. The authors state that much litigation advice appears to have desirable informational and behavioral effects, and advice with undesirable or ambiguous effects is often difficult to regulate without deterring desirable advice. The authors state that improving the presentation of information to the tribunal talks about competition can sometimes result in a reduction of information reaching the tribunal, but the competition does improve the presentation of information that is presented to the tribunal. Their account confirms that when both parties have comparable legal advice, the positive effects are more robust, and it also confirms that imbalances may have harmful or doubtful effects. This is an interesting article because where I was a magistrate, it was frequent that one party would have an attorney and the other wouldn't. There was frequently an imbalance. And so the tribunal, as the magistrate, I was constantly trying to get the information that I needed when you had people, pro se litigants, that were uninformed in the legal system and therefore sometimes didn't have the information that was needed to come to a full resolution of the case. So the tribunal then has to, while remaining fair and unbiased, seek the information in order to make a just and equitable decision. So this article talks about that at great length, about one party having an attorney versus both parties having an attorney. Obviously doesn't look at all at the situation of no attorney at all, both litigants being pro se, because the article is looking at, do lawyers improve the adversary system? So it's not looking at that pro se versus pro se fact pattern. Also this week, we're looking at going to part 4 of the book, Why Do We Punish All We Condemn? Looking at chapter 12, the undercriminalization of a problem. So it starts with a discussion of Gulliver's Travels and talks about, in Gulliver's Travels, it says ingratitude is a capital crime. So starting talking about villainies versus felonies. Why do we criminalize some conduct that society abhors, and why do we not criminalize villainies, things that we don't hold criminally responsible. So page 188 says the question of what conduct should be criminalized has long been considered, and that there are really three approaches to what should be considered criminal conduct. You can look at it through utilitarianism, the harm theory, and legal moralism. So again, page 188, looking at utilitarianism, talks about sanctions that are severe enough to deter but not to sever the marginal cost of inflicting them exceeds the marginal deterrent effect of doing so. So what's the cost benefit analysis? Also looking at having maximum utility, what benefits society the most. That we criminalize under utilitarianism all conduct that tends to lower overall utility. Going to the harm theory, that's trying to prevent through the law harm to others. It does not allow the state to infringe on somebody's liberty unless someone else's liberty is being jeopardized by the person taking the actions. Page 191, it turns to the legal moralism, also called it's when you're seeking retribution, and that it's the theory that criminal law should punish all immoral conduct, generally in proportion to the degree of the immorality. The book talks about also protecting basic liberties from state interference, and that courts have sought to defend constitutional rights, that a certain sphere of individual liberties will be kept largely beyond the reach of government. The examples it's giving there on page 192 is in relation to things such as abortion. It's referencing Roe versus Wade. Obviously, it's not completely current on some of the things that it's stating in that section. The author of the book, page 193, talks about the line between villainy and felonies, and then asks the question, are suicides, bad parenting, speech that invades someone's privacy, non-felonious, mendicancy, selfishness, treachery, greed, cruelty, hypocrisy, manipulativeness, or ingratitude any more innately connected with the self-definition of the wrongdoer than murder, rape, or theft? Like, where does the line get drawn? What's a villainy? What's a criminal conduct? And where do we draw those lines? Talks again on page 193, criminal law routinely declines to hold someone responsible for whom we are perfectly willing to blame, differentiating an actual criminal act from a mere wicked thought to do something. So it talks at the bottom of page 193, partial criminalization, the problem of comparative guilt, and talks about actual non-felonious villainies are but a special instance of under-criminalization. When we don't criminalize what we strongly condemn, that is merely one way in which condemnation and punishment can get out of sync. And so it gives you a couple of fact patterns there about a husband with a wife who's terminally ill. He ends her agony, and he is then charged with premeditated homicide or murder in the first degree, versus two men engage in a drag race. One loses control of their vehicle, and that's reckless homicide. And so the author is then asking, well, is this really what should occur in this case? When some people would argue that the husband had an honorable reason for what he did, which did not exist in the drag race situation. So the author looks further at partial undercriminalization and the volume discount problem. And so this is talking in criminal law specifically, starting on page 194 at the bottom of the page. Basically, a volume discount for crimes that people who generally commit one crime at a time are charged greater than another. The example being, if you punch someone in the face 3 different people, 3 different days, you seriously harm them, you're going to be charged with 3 felonious assaults. If you on one day punch one person, causing serious harm 3 times, they're going to all be consolidated typically into the first offense. So he talks about the volume discount, page 195, that the offender is punished less than if they had committed each crime separately, and talks about the situation of quick succession. Basically, that example I gave you, 3 punches right in a row versus 3. Over 3 days, 3 different people. So if the same crimes are sufficiently tightly sequenced, only the first crime is going to count or be charged for it. He then talks on page 196 about what he calls mop-up discounts, that if you commit both theft and then extortion, the law, somehow the offenses, the initial theft is treated like it's unimportant, and you don't cover the second one. And then on page 196, it also looks at things that are committed concurrently, so that if you carry out multiple things, a terrorist blows up several people with one bomb, thereby commits several murders, that because they're committed concurrently, again, you're going to get that volume discount, is how the author words it in criminal law. His conclusion, or taking stock, on page 197 talks about the law fails to punish a great deal that we strongly disapprove of. And even what it criminalizes, it often seems to punish much more gently than our intuitive level of disappropriation seems to warrant. He ends with the question of, but we do not, after all, really want to criminalize everything we disapprove of, but the question is why. And so he's going to look at that more in the next chapter on why everything we disapprove of, going again to the beginning, discussion about Gulliver's Travel, about how they wanted to make it a capital crime for someone to have ingratitude, but we're unwilling to do that in criminal law. So that ends this week. I will see you next week for the final module. Thanks.